The point we've been trying to make is that violence against women is a national problem. It's an appropriate thing for Congress to be concerned about, and it's not something that the states can do alone. Just 2 incidents in the last week, only a few miles from here, I think make that point. Actually molested, where the judge made the comment that it takes 2 to tango. And it's those failures to take these crimes seriously, those attitudes that that women may be to blame for what happened to them, that's what this law is trying to change.
Explain how the law came about, the Violence Against Women Act.
It was passed in 1994 after 4 years of hearings by Congress that examined the problem of violence against women. And Congress found that it was far too epidemic in our society, that it really does have a dramatic impact on women's economic choices, where they go to work, whether they walk at night, and so forth, and that the states really aren't doing their job, that they need help, and that we still have some outdated and sexist attitudes that prevent women from really being protected.
And this came to the Supreme Court how? What did the lower court do?
The first court to hear the case, the trial court, struck down the statute as unconstitutional. It went before the Fourth Circuit, which originally upheld the statute, similarly to the over 18 district courts that have also upheld the statute in other parts of the country. The Fourth Circuit then reheard the case en banc, which means that the entire court weighs in on the decision, and that's a rather rare event. And the en banc court ruled the statute unconstitutional, bringing it before the Supreme Court this morning.
In the past year, the hashtag #MeToo movement has become extremely powerful and impactful. Women have come together to come out against their perpetrators and stood strong together. But with these movements, there are still many obstacles for victims of crime against women. Through cultural, economic, and physiological impacts, we are able to explore to which the extent it has become harder on female victims after the Violence Against Women Act was repealed. In the Supreme Court case United States v. Morrison, the Supreme Court voted to repeal the Violence Against Women Act, an act put on by Congress in 1994 after about 10 years of attempts to put it in place. The Violence Against Women Act had goals to regulate crime against women, make available professional coordination of arrests, reverse myths around rape, encourage more victims to come out, enable them to accomplish more in court, and treat cases in a more sensible way in respect to the victims. The law was under the STOP program. The STOP program stands for Services, Training, Officers, and Prosecutors. It is under the Commerce Clause of the Constitution, Congress creating the federal right to be free from crimes of violence motivated by gender. The act was repealed after Antonio Morrison, a student at Virginia Tech, was accused of assaulting and gang raping fellow Virginia Tech student Chrissy Bozontala. Within the school, Morrison had 2 academic hearings and was supposed to be suspended for 2 semesters. He claimed the sex was consensual and his friend was put up as an eyewitness. It was decided that the school could only charge him with abusive language, and he was no longer to be suspended. Bozontala did not have solid evidence of the rape or assault happening and did not press charges in state criminal court. She later decided to sue under the Violence Against Women Act. Bozontala was aided by Legal Momentum, a national feminist advocacy organization. Morrison claimed the sex was consensual. In the Violence Against Women Act, there is a section on students, mostly college learning about consents. People who created the act wanted to show that just because someone didn't say no, they did not mean yes. Bozontala suffered multiple accounts of emotional distress and expressed her feelings during the 2 academic hearings between herself and Morrison. After overdosing on pills one night, Bozontala decided to drop out of Virginia Tech, changing the path of her life forever. It has often been found that women who have experienced things such as Bozontala have poorer mental health and physical health than those who have not. The act had implications for this and wanted to put in programs to help victims. Bozontala's dreams of sports medicine were long gone. Bozontala was interviewed and said, "I fell in a black hole. It was disappointment after disappointment." Although this case was originally based upon sexual politics, it ended in the Supreme Court with a basis of federalism and whether or not the act was constitutional. The act was put under the Commerce Clause. This deals with regulation. In the Constitution, it can be interpreted as solely economic or in all forms of regulation. One of the reasons it was put under this clause is because women feeling unsafe needed to be regulated, and it often affects economic decisions. If a woman is sexually harassed in her workplace, she might quit, this affecting her economic life. Many people question this claim, and it would be one of the main arguments of the defendant. Before this act was passed, there had been many studies about rape and domestic violence throughout the country, and an overwhelming amount of the cases were women being the victim and men being the perpetrator. oftentimes it being their current or prior husband or boyfriend. This was not the only circumstance that was found by any means, but it was the one to be found of the majority. It was the first and only law that was to be passed that would significantly help women against the violence that was constantly happening to them. Just some of the statistics found were each year approximately 2 million women were severely assaulted by male partners. During 1992 and again in 1993, women reported about 500,000 rapes and sexual assaults through the National Crime Victimization Survey. People the victims knew committed over half these rapes and sexual assaults. Approximately 1 in 5 adult women has experienced a completed rape. After these were found in the early 1990s, organizations and political figures took action. Many feminist groups hoped the law would bring up the conversation and recognition of domestic violence and rape. Other studies have shown that often alleged rapists will walk. Only 6 in 1,000 accused will serve any sort of time. Courts were seen as falling short in these cases. This law brought up their cases again by suing through the Violence Against Women Act, even if they lost in criminal court. Many people view rape and domestic violence differently, but stereotypes and assumption are something that are only hurting these cases and the victims themselves. The way our culture and society sees the victims is ever-changing, mostly for the good, but horrible ideas are still put out about them. People say women are asking for it, and they are a tease if they are wearing revealing clothing. The prosecution was trying to uphold the act so it could continue to protect women from bias in court cases. In the same interview that was shown at the beginning of the video, a man called in and said he was a white 60-year-old man. He talked about how he viewed it as unfair that men do not obtain the same protection from domestic violence or rape as women do under the Violence Against Women Act. Kukos tried to explain how this had been thought about and was even brought up as an argument by the defendant. She explained how, of course, men and women are both protected under the law for when they experience something such as sexual assault and domestic violence. But when statistics and studies are looked at, it is seen that women more often experience these crimes against them compared to men. Kukos wanted to put out the message that women may need extra protection as their safety may start to affect their personal lives, whereas with men it might not be as common. The case wanted to show that it should not be ignored that rape and domestic violence affects men, but it should also not be ignored that women might need extra protection against those crimes. The U.S. versus Morrison case had a large impact on New Federalism, a political philosophy about the transfer of certain powers from the federal government to the states. It impacted the power of the Supreme Court, especially within the New Federalism philosophy. Along with this, the courts reduced the power of the federal government through defining the Commerce Clause as strictly economic regulation. With the act, it showed that violence against women affects their economic decisions, such as jobs, where they go to and where they buy things. This was stripped away when the act was repealed. Women's economic decisions based upon their feelings of security was argued on Kukos' side, and in the end, Morrison's defendant team was able to argue this point strongly and push the act to be repealed. Overall, the U.S. versus Morrison case had a large impact on women and the federal government rights. It defined the Commerce Clause as economic regulation and further showcased New Federalism.